Good afternoon. Welcome to Truly Sinister. My name is Wendy, and today we are going to we're going to go over the papers of the should have been suspects' opposition to Karen Reed's motion to compel for their depositions. I've been trying to get Karen Reed's actual motion to compel, but that's the only one that's unavailable for some reason on the court docket. So we're just going to go straight to the opposition. So stick with me and we'll get right into it. Welcome back. So we're just going to get right into it so we can get this done and over with. The U.S. is playing tonight. The World Cup in the World Cup, so I want to make sure that I get to see some of that. Hope everybody had a nice 4th of July. Looks like we got it. Okay. This is the non-parties, Nicole and Brian Albert, Jennifer Alley and Matthew McCabe, and Brian Higgins' memorandum of law in opposition to defendant Karen Reed's motion to compel. It's sad that she has to do this for all of them, but it appears that that's how it's going to be. Non-parties, Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Allie McCabe, and Brian Higgins. The non-parties, by their undersigned counsel, respectfully submit this memorandum of law in opposition to defendant Karen Reed's motion to compel the non-parties to attend depositions and produce documents pursuant to various third-party subpoenas. Reed's motion asks this court to find that the non-parties waived their objections to overbroad subpoenas duces tecum because they served written objections outside the 10-day window prescribed by Mass R Civil 45D1. That request should be denied. Waiver under Rule 45 is not automatic. It is a discretionary, disfavored remedy reserved for cases of egregious, unjustified, and deliberate delay. Here, the non-parties acted in good faith. Their counsel was in continuous contact with Reed's counsel regarding compliance and scheduling, and the delay was modest and justified. So you say. These people just don't get it, you know? More fundamentally, good cause compels consideration of the non-party's objection. The subpoenas are facially overbroad, demanding inter alia, quote, all documents including communications relating to Karen Reed, end quote, all documents relating to John O'Keefe, and all communications with over a dozen named individuals spanning more than 4 years. This court already agreed at a hearing on a separate motion to compel an identical subpoena that such requests are overbroad and violate Rule 45. Reed has also been on notice of these overbreadth issues since April 27, 2026, when non-party Colin Albert, represented by the same counsel and served with an identical subpoena, timely objected. There is, thus, no surprise and no prejudice with respect to the non-party's same objections to these subpoenas. So she's supposed to assume that since he objected, they're all objecting. That's not how it works. It doesn't matter if you have the same lawyer or not. That's not how it works. He has to treat each individual party separately. With respect to the non-parties' depositions, Reed noticed deposition dates on which the non-parties and or their counsel are unavailable and without first discussing mutually available dates. The non-parties offered multiple alternative dates for their depositions, all of which fail within the court's discovery scheduling period. All of which fall within the court's discovery scheduling period. Reed declined to accept any of the non-parties' proposed dates and failed to cite any legitimate scheduling conflict in doing so. She doesn't have to tell them why she can't accept a certain date. It's none of their fucking business. Excuse my language. Reed's unwillingness to coordinate dates for the non-parties' depositions violates the spirit of Rule 45. I'd say that, the spirit of anything is just gone in where this case is concerned. There is no spirit. The court should decline to find waiver, consider the non-parties' objections on the merits, and deny the motion. 1. Argument. Untimeliness does not automatically waive Rule 45 objections. Courts uniformly hold that waiver under Rule 45 is discretionary, not automatic, and is disfavored as a remedy. The court should do the same here. I'm not going to read all of this. I'm just going to kind of skim over it because it's, these papers are so long and they basically all repeat the same stuff. So we're just going to go over the main meat of it, if I can. It says, failure to serve timely objections may waive the right to object, but the failure to act timely will not bar consideration of objections in unusual circumstances and for good cause shown. It says that the waiver is not used lightly and that the waiver is reserved for cases where the offending party committed unjustified delay in responding to discovery. It says waiver is appropriate where the responding party's conduct evinces a deliberate pattern of delay and is egregious. I would say that applies here. They are finding ways to delay, and it is becoming egregious. The waiver should only be found in the absence of mitigating considerations that favor the subpoenaed party. Whether waiver applies turns on the totality of the circumstances. Thus, the question is whether the non-party's conduct was egregious and reflected a deliberate pattern of delay, or whether unusual circumstances and good cause warrant consideration of their objections. As demonstrated below, this case falls squarely within the latter category. Good cause warrants consideration of the non-party's objections. Courts have identified several factors establishing good cause and unusual circumstances sufficient to overcome untimeliness. 1, the subpoena is overbroad on its face and exceeds the bounds of fair discovery. 2, the subpoenaed witness is a non-party acting in good faith. And 3, counsel for the non-party and for the subpoenaing party were in contact with respect to the non-party's compliance prior to the time the non-party challenged the subpoena. All factors are present here. The subpoenas are paradigmatic examples of facial overbreadth. Schedule A requests all documents, including and we all know what Schedule A is. It's basically documents and communications relating to Karen and about Karen, John, anybody involved in the case. So that is pretty broad, with over a dozen named individuals. These requests have no temporal limitation, no subject matter limitation beyond the broadest possible nexus, and would sweep in vast quantities of irrelevant and personal communications and documents. At hearing on non-party Colin Albert's motion to compel in the above caption action, this court already observed that an identical subpoena was overbroad. The court's prior conclusion provides compelling grounds for considering the non-party's objections here, where the subpoenas are the same. Okay, but he didn't say that he didn't have to give a deposition. He still is expecting a deposition from Colin Albert. He didn't get out of it. So he just narrowed the subpoenas requests as far as communications go. That's all he did. Moreover, Reed suffers no prejudice or surprise should the court consider the non-party's objections. It says that she should have known because prior to this date, 6 weeks prior, before she filed this motion, there were non-parties objecting to the identical document requests. So she should have been expecting this. They're saying that the objection should have been entirely foreseeable and foreseen. No prejudice results from considering the non-party's objections. The non-parties have at all times acted in good faith. Counsel accepted service on the non-party's behalf on May 5th, 2026, served written objections on June 1st. Well, that's quite a long time to wait. Indeed, as the court is aware, between May 5th and June 1st, counsel engaged in regular dialogue regarding the appropriate scope of the Colin Albert subpoena, which is identical to those at issue in this motion. Like I said, it doesn't matter. Every person involved in that this lawyer is representing has to be dealt with separately. She can't just assume that they're going to object just because Colin objected. Finally, nothing about the non-party's conduct was egregious, nor did it evince a deliberate pattern of delay. I would have to argue with that. The delay was modest. They served objections on June 1, approximately 17 days after the 10-day objection period. Well, there you go. I mean, approximately 17 days after the... Come on. After the 10-day objection period expired. So that is that's pretty big delay as far as I'm concerned. They simply required additional time to review the sweeping demands, obtain counsel's analysis of the facially overbroad requests, and prepare substantive objections. Under the totality of the circumstances, the non-parties' brief delay in the context of their good faith engagement and the patent breadth of the subpoenas does not warrant the drastic result of waiver. The mitigating considerations here overwhelmingly favor the non-parties. And this one says that as set forth above, and as this court has already determined in connection with an identical subpoena, the document requests are facially overbroad and exceed the bounds of their fair discovery. For the same reasons outlined in the briefing regarding Reed's motion to compel Colin Albert, the instant motion to compel document production should be denied. Footnote 1. On June 18, 2026, counsel for the non-parties and Reed's counsel met and conferred on the instant motion pursuant to Mass Super R9C. While the deposition portion of the motion was discussed, counsel did not discuss the scope of the document portion of the motion given reads staunch position that the non-parties waived their right to object. Staunch, huh? What a word. The motion to compel deposition testimony should be denied due to Reed's refusal to accommodate the non-parties' availability. Reed's demand that the non-parties appear for depositions on dates that she unilaterally selected likewise cannot be reconciled with Rule 45. Non-parties have a different set of expectations than parties to the litigation, and courts must be solicitous of the burdens placed upon them. This concern carries particular force in the deposition context because depositions are the most burdensome and intrusive form of discovery, which is exactly why they don't want them. That's exactly why they don't want to give them, because they don't want to have to tell all. They're scared. Notably, the non-parties have never refused to be deposed. To the contrary, on multiple occasions, the non-parties offered various alternative dates for the depositions, all of which fall within the court's discovery scheduling period. Reed's counsel has simply refused to accept those reasonable alternative dates. Well, why does she have to accept your date suggestions and you can't accept hers? I don't get that. Instead, during the June 18th Rule 9C conference regarding the instant motion, Reed's counsel did not convey that they were unavailable during the alternative dates proposed. Rather, they relayed that Reed wishes to take the non-parties' depositions on earlier dates because it is their preference. Okay, well, you said that they weren't available at the later dates. She's just coming up with earlier alternatives. What's the problem? Then again, it says Rule 45 demands the opposite, a good faith effort to avoid imposing undue burden on non-parties, which necessarily includes working around their reasonable scheduling constraints. Reed's refusal to do so in service of the strategy alone is precisely the sort of conduct Rule 45 D1 forbids. Accordingly, to the extent the motion seeks to compel the non-parties to appear on Reed's unilaterally noticed dates, it should be denied. The court should instead direct the parties to proceed on the reasonable alternative dates the non-parties have offered within the discovery period. Conclusion. For the foregoing reasons, the motion should be denied in its entirety, and the court should grant any further relief deemed just and proper. And then, of course, it has all the, lists of all the papers and documents that they were asked to, with all the exhibits and the prior motions served, etc. So we don't need to go through all that. So it sounds like they might get their way as far as the court narrowing the the amount of documents and communications that they're asking for, but I don't think they're going to get out of their depositions. So, good luck to them. So next we're going to go over Karen Reed's response to their opposition. I don't know why her original motion to compel isn't available, but I've been trying, for about a week, and I haven't been able to get it. So, okay, defendant Karen Reed's reply to non-parties Nicole and Brian Albert, Jennifer, Allie, and Matthew McCabe, and Brian Higgins' opposition to her motion to compel. Delay appears to be the goal and not just a symptom of the manner in which Nicole and Brian Albert, Matthew and Jennifer McCabe, Allie McCabe, and Brian Higgins, collectively the delinquent non-parties, have responded to defendant Karen Reed's subpoenas. In response to validly issued subpoenas, these individuals ignored Rule 45's deadline for objecting to document production and belatedly claimed that almost all of them were fully unavailable for more than a month from their subpoena dates, evidencing their desire. I just lost my place. Evidencing their desire to obstruct Reed's ability to take discovery required for her defense. Indeed, in the 9C conference concerning these subpoenas, among other topics, the delinquent non-parties counsel even suggested that Reed's counsel should simply accept the late deposition dates his clients had chosen, because by the time the court heard and decided Reed's motion, all the interceding time would have passed anyway. What a dick. Rule 45 has specific deadlines and requirements so that a party to a case may compel witnesses to provide discovery in a timely manner, while respecting the non-party's right to avoid undue burden. Although Reed has always been willing to accommodate reasonable scheduling conflicts by choosing new dates in the same time frame as a subpoena date, the court should not permit these non-parties to unilaterally impose their will on the discovery schedule in this case and prejudice Reed's ability to prepare her defense within the discovery period. Reed replies separately to the delinquent non-parties' arguments regarding document production, and deposition dates below. Okay, the document production, in their opposition, the delinquent non-parties claim the good cause failure and refusal to assert timely objections within the 10-day window. But they provide no explanation for why they ignored Rule 45's deadline. Instead, they simply rely on the very objections they belatedly asserted as a reason for the court to ignore the deadline. The court should reject this circular reasoning, which would render Rule 45 toothless. This is why failure to timely and properly object to the subpoena generally constitutes a waiver of all grounds for objection. The delinquent non-parties then asked the court not to compel them to produce any documents based on a single paragraph and reference to an opposition filed in response to a different motion by a different party, Colin Albert, which is what I was saying. However, much of Colin's opposition is distinguishable because it focused on the fact that he claims to have left the house at 34 Fairview Road before Reed and John O'Keefe arrived in the early morning. In stark contrast, the delinquent non-parties, other than Allie McCabe, were undisputedly in the house at the time, and their alleged conduct forms the core of the quote-unquote false narrative the plaintiffs allege Reed promulgated, causing them compensable emotional distress. If the delinquent non-parties had concerns about specific requests and the burden they would impose, they were required to, at the very least, describe them to the court with sufficient specificity so that the court could balance the burden with Reed's need for this evidence. But they have not done so and have never identified any such specific burden to Reed. It is particularly important for these particular subpoena recipients to specifically identify any undue burden they claim to be facing, because many of them are also plaintiffs against Reed in a separate defamation case pending before this court relating to the same narrative, a role they voluntarily took on, knowing that it would require them to gather, review, and produce whatever responsive documents they may have. As to the delinquent non-parties' deposition dates, this reply can be brief. Reed offered to reschedule any of the dates to other close in time to the originals to accommodate reasonable availability issues. The delinquent non-parties simply repeated the dates they had proposed in the first place, ignoring Reed's right to take the depositions comfortably within the discovery period rather than facing the task of taking multiple highly relevant depositions in rapid succession at the end of the court's discovery schedule. Third parties' right to be free from undue burden does not allow them to unilaterally dictate the deposition schedule for this case in this manner, and the court should prevent them from doing so. Yeah. That's it. Huh. I guess that's it. Respectfully submitted, Karen Reed, by her attorneys. And then it has the certificate of service, and that's it. So, like I said, it was going to be a quick one tonight. Don't forget to like and subscribe and comment. And just remember that tomorrow is always the first day of the rest of your life. And ciao for now. See you later.